127139, State of Kansas versus Kamahl, Bobian.
Morning, Your Honor. My name is Randall Hodgkinson. I'm appearing today on behalf of Kamahl Bobian. I request 3 minutes for rebuttal, please.
3 minutes, Cran.
Your Honor, I would remind the court that this case is a first-degree murder case, premeditated murder case out of Riley County. My client was convicted of killing his wife, SB. There's a lot not disputed in this case. It's not disputed that my client killed his wife, SB. That's not disputed. My client's state of mind and culpable mental state is hotly disputed in this case, and is the primary subject of the issues raised in this appeal. My intent today is to focus on some of the differences between my colleague and I on issues 2 and 3. The court may have other directions for me, but I'll focus on this. First of all, issue 2 has to do with the refusal of the district court to give lesser included offenses with regard to, in particular, reckless second-degree murder and involuntary manslaughter. The first point I want to raise, again, just looking at the things that my colleague and I disagree with about. In my brief, I argued that one of the things that the district court should have instructed was involuntary manslaughter based on misdemeanor manslaughter. And my colleague has asserted that we didn't raise that below. We were raising that for the first time on appeal. And I would disagree with that. Certainly when you look at record 19, page 869, I think, 859. My attorney in this case, my trial attorney, said we want all the lesser included offenses. We want involuntary manslaughter and cited the pattern instruction without limitation. Now, my colleague is correct that when they had discussion about factual appropriateness, my trial attorney in this case focused on the reckless involuntary manslaughter, but there was nothing in the request that limited that.
Is that our standard for preservation and clear error? Just to say, Judge, I want every instruction that the law requires you to give. For example, like, is that enough?
That's what I keep begging all of my trial attorneys to do in response to this court's rulings that under 2234-14, all you have to do is request the instruction and then you've complied with the statute.
You don't have to be specific. You're just saying you can make a general prophylactic request for every instruction that I'm entitled to receive.
The attorney in this case at least said we want every lesser included offense down the chain, including involuntary manslaughter without limitation. And
that's enough. That's your argument.
That's what the statute doesn't say anything different.
Do we have case law that says that? Or would that be a new rule, at least as far as our case law is concerned?
It would be a new rule if you said you have to do more than that. I mean, I'm not aware of anything. The statute says you have to request the instruction. My attorney in this case requested involuntary manslaughter without limitation. Now, the test, when we get to factual appropriateness, then is we're going to look at the whole record. And so, no, I mean, it's certainly our position that was requested, involuntary manslaughter without limitation, and therefore it's treated the same. And by the way, the state agrees that it was factually appropriate. I wanted to shift to the reckless second-degree murder and the reckless involuntary manslaughter that the trial court refused to give, and my colleague agrees was requested. And again, the test here is if the district court had given those instructions, and if my client had been convicted of either reckless second-degree murder or reckless involuntary manslaughter, would this court have reversed based on insufficiency? And I think the answer is clear under Gregory and James in these kind of cases, where my client testified, agreed, or at least there are statements, he didn't testify, statements that he killed his SB, but that he didn't intend to do so, and that the circumstances that would you have affirmed this on a sufficiency analysis if he was convicted of a reckless killing? I think the answer is yes.
Shifting to the harmlessness inquiry, what's your best argument for a reasonable possibility that a jury could find that stabbing someone, whatever, 7 times is a reckless act?
So I just want to be clear. You're specifically using reasonable possibility. So,
Yeah, or you can reframe it however you want.
yeah.
Yeah. I mean, that's what you want, right?
Yeah,
That's
that's
the
the
standard you want.
I mean, we think we went under any harmless understanding.
Understand.
Here, but so I don't think it really matters that much. So yeah, the testimony in this case is the client says, Mr. Bobian says, I didn't intend to kill anybody. And we can look at a lot of the circumstances, and the jury is required, as this court has often said, to sort of sift through and determine credibility of different situations. One thing you could say is we actually don't have a lot of information about Mr. Bobian's intent, and that's not uncommon. It's hard. I mean, it's not always the case where people say, "Here's what I intended to do this day." So you have to get to the circumstances. I think the court, you're sort of saying, had multiple stab wounds, and so that's the situation. Although my client testified that he remembered his wife being stabbed once or twice, but not several times. It's a little bit tied into the first issue. Again, is there a reasonable possibility or probability that a jury could have formed a reasonable doubt that we don't know what his intent was? But whatever the situation was, it was reckless. And so in that situation, the jury, had they been given the
How
option,
does
could have
someone-
said it was something different.
And maybe that's the best argument you can make, but it strikes me as a stretch to think that a reasonable juror would have a possibility of concluding that 7 stab wounds in which the body is then taken in a van and dumped in a field is reckless.
So one, I would push back on your characters. The jury doesn't have to find anything. They just have to form a reasonable doubt about whether he had the specific intent. And so in light of the evidence, what evidence did the state have that he had that specific intent? And not a lot, right?
Well, isn't just the evidence I recited pretty strong evidence?
No. I mean, it's circumstantial evidence. I concede that. But is it so strong that no jury could form a reasonable doubt in light of that evidence?
That you just did this on accident because you were reckless?
Or because other circumstances were occurring in the situation that having a knife out and when you're having heated discussions is in and of itself reckless?
Okay.
Could a jury say, I have a reasonable doubt about whether the state's proven, this isn't a case where you have somebody that said, I'm on my way over to kill my wife ahead of time. That situation, Your Honor, I'd be like, wow, it's going to be hard to get around the evidence of intent. That's not this case at all. It's not this case at all. Could a jury just have said, we don't know what his intent was, what his state of mind was. It seems like he was in a lot of weird places. And if that's the case, could one or more jurors form a reasonable doubt that we don't know what his intent was? If that's true, then the question is, well, that's the answer to the harmless error. That a jury could then, had they been given the option, landed on a reckless offense. Given my time, I won't spend a lot of time on what I think the harmless error test should be on that second issue. We have a disagreement about that. I just would highlight that I understand that the court has said you don't have, for example, that the state constitution and the federal constitution, the right to jury trial doesn't include the right to have lesser included offense instructions. But if your only defense is, I think this was a lesser included offense, it's our argument that that's your defense, just like compulsory. I won't belabor that. I did want to spend some time on the third issue, on the prosecutorial error issue, and the second part of that, where I think my colleague and I have some disagreement. In this case, the prosecutor said, because they did give a lesser for intentional second-degree murder, but the prosecutor said, if you find him guilty of first-degree murder, don't even look at second-degree murder. Don't even look at that. You're done. And our argument today is that that's a misstatement of the law, that's not true. And my colleague has cited, and correctly so, that this court has said that, it's rejected previous claims that we have to tell the jury that they have to consider everything contemporaneously. I understand that. But I think maybe the comparison or analogy I would use is like, for example, for reasons that escape me, but here it is, that we can't tell the jury that they can nullify. We can't tell them that. Neither the judge can tell them that, attorneys can't tell them that. But we also know that a judge, and I assume a prosecutor, can't tell a jury that they can't nullify. And this court has said that's the difference. And so this circumstance where this court has said, look, you don't have to direct the jury that they have to consider everything contemporaneously. Does not stand for the proposition that they can't ignore lesser included offenses. But that's not correct either. That in fact, in Sims, in response, when this court abandoned the idea that juries should be instructed that they have to consider greater and lesser offenses contemporaneously, said, and we don't really have to worry about the due process implications of this because the jury is told that they still have to consider these things in relation to one another. And if that's the case, then your concern, counsel in Sims, that the jury's not considering these lessers goes away. You're instructed to do that. But the prosecutor's argument in this case runs exactly contrary to this, saying don't compare them. Only look at first-degree murder. If you find that, you're done. And I do think there's a difference. If you're telling somebody, here, I want you to compare these two things, but only look at the one thing. And if you decide something about that one, no, if you are going to compare two things, you have to look at both things. That's what the statute says. That's what the instruction in this case says. That's the instruction that this court relied on to say there's not a due process problem here. But when the prosecutor comes in and says, actually, don't look at both things, only look at this one thing. And if you decide that, don't even look at the other thing, we think that's a misstatement of law and therefore procedural error. Your Honor, that's the completion of my comments.
Any other questions?
Thank you.
Thank you.
Good morning, Chief Justice, Justices. May it please the court, David Loudon, Deputy Riley County Attorney, appearing on behalf of the state of Kansas. This morning, I'll focus on what Mr. Hodgkinson has focused on as far as the briefs. I think the issues have been briefed really well. I would largely stand on my brief, but I will answer or rebut some of the things that he said here this morning. With regard to issue 2, our position has been in the brief and continues to be that the defendant did not present any factual basis for a reckless murder instruction, whether that's under second-degree murder or involuntary manslaughter. Whether you believe the defendant's statements to the police after the crime, or whether you believe his testimony at trial. And if you focus on his trial testimony, it's, I was holding a knife, I was going to cut up some clothes. So there's nothing reckless or illegal about that. She comes at me, he reflexively moves the knife, it stabs her, she falls to the floor, and she stabs herself again. Okay, so what we know from that is that would be consistent with his claim that he only remembers, or that he only stabbed her, or there was only 2 stab wounds, 1 or 2 stab wounds, I think is maybe how he said it. But the facts of the case with the showed that there were 7 stabbing or cutting type wounds. So how does that happen?
But isn't that weighing the evidence?
I don't think so, not with respect to determining whether that was actually reckless. And that's why I'm focused on what he had to say. If you take his comments at face value, then he didn't act.
I understand that part of the argument.
Yeah.
I guess I was talking about the number of stab wounds being inconsistent with that theory. But wasn't his position that the reckless component is in the midst of argument, taking out the knife in the first place, then the accident? I understand it's self-serving, but
Right. No,
it's a statement.
I don't think in and of itself, even if that's what he did, in which I don't think that's what he testified to necessarily. But even if that were the case, I don't think that in and of itself is reckless or shows any recklessness at all. If I'm just pulling out a knife and standing there with it, if I'm doing nothing with it, I don't know how that's under our high level of standard for recklessness. I don't know how that reaches that level.
Do you agree the reckless instructions all the way down was preserved in the instruction conference?
For the two reckless ones, for the reckless second and then the reckless involuntary, yes. Those were discussed and refuted and discounted by the judge. With regard to the involuntary on the protective order, I don't agree that that was preserved. I understand his argument being, you know, we asked for everything, and we all know that the judge has a duty to give all lesser included instructions that are preserved by the evidence or supported by the evidence. But at the same time, you know, this is the trial situation is one where the judge will take his lead from the attorneys, and if they're not making an issue out of something, that's probably why it wasn't even discussed. I don't think that was on anybody's radar, and I think it was a fairly new legislative enactment. I don't think that's something that had been around. Now, that doesn't excuse the court from having a duty to raise that. Our position is essentially that he doesn't get to say something in general, not bring it to the court's attention, much like an objection. You have to be specific about it and timely about it. And he wasn't specific about it and wasn't timely. He didn't raise it till now. We submit that the clearly erroneous standard would apply. But make no mistake about it, whether it's clearly erroneous, non-constitutional harmless error, or a constitutional harmless error standard, the state believes that if this is error, and it would be error on the violation of the protective order, because we have conceded that there is no possibility under any of those standards that the outcome of trial would have been different, largely in part due to the verdict in this case, that the jury found the defendant guilty of premeditated first-degree murder. In order to do that, they would have had to find premeditation and the intent to kill, which again, that doesn't foreclose the possibility that they could have found a verdict for the violation of protective order, because there was a killing in the scope of violation of protective order. But there is nothing about our law that says, and this kind of goes to the third issue a little bit, is if the jury finds that if a defendant is guilty of the highest crime charged, even if they find him guilty and go down the verdict and form and find him guilty of that lesser crime too, that crime would be dismissed basically, or that verdict would be disregarded, and the highest crime would be remain in place. So for that reason, we don't believe that there would be any different verdict had that instruction been given on that one. Same reason and so with regard to the reckless ones, however, not only would that apply, but it would also apply the fact that it is not factually appropriate. We don't believe any issue regarding error is on that one. So going to the third issue on that, the state's comments regarding once you find him guilty of first-degree murder, don't move on to the second. It's not error, first of all, because it's exactly what the instructions told the jury to do. I disagree with Mr. Hodgkinson here today, indicating that the jury says, or the jury instructions say, consider all these together. That's not true. The jury was instructed on the primary count of first-degree murder. As to any lesser included offense, very standard language, no surprise to this court, I'm sure. If you can't reach a verdict on the first count, then you can go to this lesser included offense. There's nothing in the instructions that tells the jury that they had to consider everything together before they reached their verdict. This court has agreed with that position, as Mr. Hodgkinson has noted. He's claiming that the statute supports that version, but it doesn't. The statute indicates, if I may here, in essence, what instruction number 7 said is, when there is and I'm paraphrasing, when there's a reasonable doubt as to which of two offenses a defendant is guilty, then you may only convict him on that lesser offense. Well, the predicate is that you have to have two offenses in which you have a reasonable doubt. If they find him guilty of premeditated murder, there is no reasonable doubt and no question about two offenses. So they stop, and that's exactly what the prosecutor asked them to do. So in short, we don't believe that the prosecutor committed any error by following the instructions. In order to find that there is some kind of basis for relief here, you'd have to find that the prosecutor did something outside of the instructions, which the prosecutor did not do. For that reason, I would submit the rest of the issues on the brief.
Okay, before that, would you at least address the claimed prosecutorial errors with respect to multiple, what we've come to call we know statements?
Yes, it is unfortunate that those occur. But I think based on what I've put in my brief and what this court is probably keenly aware of from its precedent is that this court does not just merely look at those words and say, okay, that's an automatic error by saying something. For instance,
well, let's focus on the first claimed error. Prosecutor said Mr. Bobian intentionally killed SB. We know that happened. Is that error?
No, as indicated in my brief, I think if you look at that in context, that's not a formal opinion. It was something that they use, prosecutor use kind of colloquially.
But haven't we said in our case law, we've been pretty strict about this, that if you use these words, we know, you better be referring to uncontroverted evidence. And if you're not, it's error.
That is true, but as I noted in my brief, there was something even stronger than that, which this court found in King, where the use of the word "I believe" was not treated in the manner that you're suggesting right now, as far as, okay, this is automatically error. I understand at the end of the day, my entire argument's going to fall back on harmless error at some point in time, because that's probably my strongest argument. But I do think that I don't know that based on this court's law that it is absolutely in every instance based on.
Well, it is interesting that you review it a lot of trial transcripts and different prosecutors phrase these different things differently.
Right.
So you have a lot of variation in these little phrases. We've been very specific about the "we know" phrase. You referenced an "I believe" phrase, and sometimes we treat those differently. So that leads into my next question, which is, I don't recall a case, there may be some, in which we've evaluated the slightly different phrase, "you know." I wanted to get your take on how this court ought to evaluate a "you know" statement as opposed to a "we know" statement. And is there any difference?
Oddly enough, I think I might have one in the works of the Court of Appeals on that, but I don't really view it differently. And again, that would fall under the umbrella of.
So you think we ought to apply our "we know" case law to the "you know" statements?
I think so, and for this reason, and this is why I started with when this court is faced with one of these situations, you generally look at it in context to determine what was trying to be conveyed. There are some colloquial phrases that people use, and I can't say 100% that's why this occurred in this case, but when prosecutors are up talking, or judges or defense attorneys for that matter, they say things that are comfortable, even though we caution against using those comfortable phrases.
Well, I think that the rationale that this court has given for treating we know statements with a strictly, let's just say, is because it's that royal we brings in all the authority of the state to bear in a vouching kind of a way. Is the same true of a you know statement?
When you state it that way, no. You know, I just want to push back a little bit. I know that, you know, it's one of those situations. If, you know, you have dealt with this a lot over the years, and it gets to the point of, you know, how many times do you have to say this before people start figuring this out and not making this mistake?
What's the answer to that?
I wish I knew. I wish I knew.
It does get, I mean, this is a continuous, at least once a docket kind of thing.
It definitely is. And as I tell people in my office, you know, it's like that one slip up by you cost me hours of work. Okay. It costs everybody hours of work. And I think that's why in part in my brief, I also say, you know, when you step back and look at this, I mean, obviously back in, you know, I'd say, let's just say late 90s. There was a lot of this stuff going on, even far worse, you know, calling people names and doing that. This court put a stop to that and said, okay, we're not doing that anymore. And I understand that this court has to have, you know, for lack of a better term, a bright line rule regarding some of the language that's used, because when we look at things objectively, we say, okay, how do we tell if something is an opinion? The easiest way to tell something is an opinion is by the terms we, I. Okay, those are easy targets. But, you know, the court has looked at it as well and said, look, okay, that doesn't necessarily mean they're giving an opinion. And if you look at it objectively in this scale too, isn't the entire closing argument the view or the opinion of the prosecutor in its case? I think everybody understands that it probably is on some level. So then it begs the question, if they slip up and say this other thing, what are they really saying? Are they trying to say something in context? And if the answer is, look, we're just going to call it error, and then the rest of it, we're going to submit to harmless error, maybe that's the bulk of my argument. And that's why I say maybe it falls back on that eventually. Because ultimately, I think everybody understands, especially from the jury instructions, what the jury is constantly told through instructions, follow the instructions. The instructions say that the prosecutor's statements are not evidence, are not to be disregarded, or to be disregarded if they aren't supported by the evidence. And, you know, as I point out in my brief, if we substitute I submit into that, it appears that we're not having the same conversation, because this court has said I submit is okay. So what is the real difference between I submit, we know, I believe? I mean, what is the real difference? I don't know. And that's why I'm taking the position I've taken on this thing. And I just ask this court to maybe look at that aspect of it. Ultimately, in this case, I think it's, I see my time is out. It is going to come down to harmless error, regardless of what this court says. But a rule that fashions something in this manner, even though you've said it once before or twice before, might be helpful. I don't know how you're going to say that to make it worthwhile. Anyway, I ask this court to confirm or affirm the convictions in this case and affirm the district court. Thank you.
Your Honor, I have just a couple points. First of all, with regard to the factual appropriateness for reckless second-degree murder or reckless involuntary manslaughter, I also just wanted to point out that under Kansas law, under statute, if there's evidence of intentional conduct, there's evidence of reckless conduct. And so under Kansas statute 215202, to the extent that there's evidence of intent, and I haven't said there's no evidence of intent, there's evidence of recklessness. And so this court would.
What is the reckless conduct? Is it taking the knife out? What was the reckless?
It could be that, but for the statutory argument I'm talking about, it's the Kansas legislature said.
No, I know.
Okay.
I've changed the subject.
Okay.
All
No,
right.
I'm saying it's a matter of law. That's it.
Right.
But in this case, it could be that. I mean, again, and in fact, I don't know that we have to show it. It's just he said, I admitted that I mean, that the very base of it is, I admit that she was stabbed, that I stabbed her, or at least that she was stabbed. But I didn't intend to do that. And so is stabbing somebody, even if you don't intend to do something, is that at least reckless?
But
Yes,
what evidence supports that besides him saying that? Or is that enough?
that's enough. That's enough for recklessness. When you look at things like James and Gregory, right? That somebody can do an intentional act, but not have the accompanying intent.
I don't know.
I can stab somebody, but not intend to kill them. But it's almost certainly reckless to do so, right? So that's the base, at the very, very base of it. I mean, we can get into the, is it reckless to get a knife out when you're having a heated argument with somebody, or to have a knife in my hand and move it when somebody's coming at me? That might be evidence of recklessness too. I think it is. But I don't even know if you have to get that far. You could just say, he admitted that she was stabbed, but he didn't have the intent to kill. Under James and Gregory, is it still reckless though? Would that be evidence of recklessness? And I think the answer is yes. The last point I wanted to make, and I wanted to point out as I was reviewing this case that part of the state's response to, if you find it error to not give the reckless second-degree murder, is that there was a second-degree intentional murder instruction given in this case, and the jury did. But I find it a little bit difficult to understand where the prosecutor said, explicitly told the jury, don't consider second-degree murder, but then argued to this court that it's harmless because the jury didn't find second-degree murder.
Wasn't that in the context of basically an order of consideration? The prosecutor said, the state's argued that the prosecutor's argument was consistent with the instructions. Consider the first charge, consider the primary charge. If you can't reach a verdict, consider the lessers. And why is that wrong?
Yeah. So, and this is based on Sims. I mean, when we argue, or when defense attorneys argued that, look, that's impeding, that instruction impedes whether the jury actually considers lessers, this court said, no, it doesn't, because we give the jury an instruction that also says, if you have a reasonable doubt between the two things, then you have to go with the lesser. And that shows, that evidences that the jury's still considering all of them.
Did they get that instruction here?
They did get that instruction here. But then the prosecutor said, don't follow that instruction.
Well,
Only follow this one instruction.
is that really what the prosecutor said, if you find him guilty of premeditated, then you stop.
That he said, don't look at second-degree murder.
How's that different than you stop?
That's contrary to the instruction that says, if there's a reasonable doubt between two things, you have to go with the
before
lesser.
a decision is made, is it not?
I'm sorry?
I don't mean to be argumentative. I'm just trying to drill down to.
Yeah.
Is there a difference between what you're arguing, which is prior to reaching a decision, you should consider all of them and weigh them against each other, versus once you have reached a decision, you need not do anything further?
Can you restate that, Your Honor?
Well, maybe. We're sort of parsing out a very fine line here.
Yeah.
Between before you reach a decision, before you reach a verdict, you need to weigh all of the primary charge and the lessers. Versus once you have reached a verdict, you don't need to do anything else.
And the prosecutor said, in this case, explicitly said, don't even consider second-degree murder.
Wasn't it after you've reached a verdict? Wasn't that the context of the statement?
But it's still, don't consider second-degree
So
murder.
you don't think there's any difference between those?
My concern here, and when we see this argument coming up sometimes by prosecutors, is I don't think Sims or any of the cases cited in Sims is for the proposition that the jury still doesn't have to consider lessers when it's making that determination of whether
even after it's reached a verdict.
I think it's your turn. I think you're putting the cart before the horse. You can't reach a verdict until you've considered the lesser.
Okay.
That's the problem here. But the prosecutor in this case said, don't even consider the lesser. If you've reached a verdict, you don't even need to consider it. And I don't think that's consistent with Sims. That's why I think the argument is improper. I've used my time and more, Your Honor. Thank you.
Thank you. Thank you to both counsel. We will take this matter under advisement.